William Wagener here at the Orange County Ronald Reagan Federal Courthouse, reporting for On Second Thought. Judge David Carter has just decided not to throw this case out, but to set a scheduled time for motions to be put into court for preliminary and for discovery. He's laid out the dates. He set the time, the next time to be October 4th. Orly TAITZ is coming down. She has a statement to make, and she had a key witness named Lucas Smith, who flew in from Kenya apparently, and she made statements that she was concerned for the well-being and that he might even be killed because of the evidence that he wanted to get into court today. In spite of that, the Judge Carter entertained the concept he could let this be testified to under oath today, though he's not inclined to do that, but he suggested to the U.S. government attorneys that this might be even in their benefit to hear what the evidence is. So if he rules against her motion to dismiss because they filed a last-minute motion Friday that it was a political question and the court had not jurisdiction, if he rules against that motion, then they would have a heads up on what's coming down the line. Dr. Orly TAITZ.
Well, Judge Carter has already told the U.S. attorneys representing Mr. Obama and other defendants in this case that a motion that they have filed to dismiss due to lack of standing typically do not get granted. He gave them an indication. He stated about 96% of such motions are not granted. He gave them an indication that it's very unlikely that such motion will be granted by him. He also asked them what would be the harm for the U.S. Attorney's Office to allow a key witness who has been in Kenya, who has information in regards to Mr. Obama's Kenyan birth certificate, to testify in court as a preliminary or a voir dire or have a deposition, and the U.S. Attorney's Office refused to cooperate on this issue. And the question is, who is Department of Justice is representing? Who is U.S. Attorney's Office representing? It is their job, it is their position, it is their mission to represent us, the people of the United States of America, we the people, to protect us against fraud, against illegality, against usurpation, to make sure that somebody who is not qualified to be the President of the United States is usurping the position of the President and the Commander-in-Chief. And therefore, U.S. Attorney's Office needs to provide an answer to the people of the United States of America. Why are they stalling the process? Why did they refuse suggestion by Judge Carter to have a deposition? He specifically asked them what would be the harm. The witnesses here, they're here, why not have a deposition? And they refused to do that. We had also another issue. As you know, we have about 50 plaintiffs in this case. Most of them are high-ranked members of U.S. military. We have a number of state representatives from different states. And it is a large case. And unfortunately, what happened here is that two plaintiffs in this case, Wiley Drake and Markham Robinson, wanted to be represented by Mr. Gary Kripp. I have opposed it due to several reasons. First of all, he stated that they didn't consent to be in this case. If Mr. Drake and Mr. Robinson, according to pleadings filed by Mr. Kripp, didn't consent to be plaintiffs, then I properly removed them from the case. They should not be in the case, and Mr. Kripp should not be in the case as well. Another issue that we had is that Mr. Kripp has a completely different legal theory upon which he operates. As I stated, I'm operating based on this theory of Amerique de Vattel that is provided in the Law of Nations, that was used by the framers of the Constitution, in that in order to be the president and natural-born citizen, not only you have to be born in the country, you have to have both parents citizens of this country. The problem with Mr. Creep being part of this case is the fact that time and again on the record in radio archives, he opposed that theory, claiming that parentage is not important. This is somebody who should be an attorney for the defendants, not for the plaintiffs, and it is a travesty of justice for him to be my co-counsel on the case, even in a small position representing two plaintiffs. Another issue that we had is that we have filed a state case together. Nearly a year ago, Mr. Creep took off for Hawaii. He showed up one day before the Electoral College meeting, and at that time he scheduled the case for March, and the case was dismissed as moot. That was the case against Secretary of State Deborah Bowen, and my grave concern was that just like Mr. Creep has stalled and sabotaged the state case, he will stall and sabotage this case as well. And we had an example of this just today. Judge Carter stated that he can rule on Friday in regards to the motion presented to him. He can rule on Friday. Mr. Creep stood up and said that he needs more time, that he just became a co-counsel on this case and he needs more time. So we've got already a problem where he is stalling the second case that I have filed, and that's a serious problem. So I do hope that Mr. Drake and Mr. Robinson just withdraw from this case, file a different case with Mr. Creep, go at their own speed, and don't sabotage this case. And I do have a few plaintiffs that would like to make. We have here an attorney, officer of the court, Pam Patterson,
Okay.
and she can swear this witness.
I,
Cynthia Davis,
state that under penalty of perjury,
state that under penalty of perjury,
all that I say is true and correct, so help me God.
all that I say is true and correct, so help me God. I just want to say I love the Constitution of the United States, and we owe it to the people that we represent. Our whole country is counting on us to do something that's going to say we mean what our forefathers bled and died for, so we could have a Constitution. And I represent people in my district, and when I got elected, I took an oath of office promising to uphold and defend the Constitution of the United States. So if we can't get some good answers, it will make a mockery of the Constitution. And that's why it's important for all of us to come together and say we're Americans, and we expect people to stay together, and what's written by our forefathers is what still counts today. So,
Mentioned this, Representative Smith is a state representative from Missouri, and you have worked on the issue of birth certificates.
I have.
You have mentioned that before, and what did you find in regards to the birth certificates and the fact and whether those can be changed retroactively by the state?
Oh yeah, I studied the question of birth certificates, and most of the states can legally falsify birth certificates. They do it every time a child's been adopted, and they take the original birth certificate, and instead of just simply redacting the information, they will put on the birth certificate the name of the adoptive parents as if they were present at the birth. And this happens all the time. And most John Q. average citizens have no idea how pervasive this practice is and how common it is for a state to put forth a birth certificate as if it's accurate when it really is not a true statement of what happened at the time of birth. So anyway, I'm glad to get to visit your lovely state of California, and I'm here to help the cause. I'm not a lawyer, but I certainly applaud all of the citizens who care enough about this country to say we're not going to let our Constitution go in the trash.
This is Officer Clinton Grimes. He has been a Navy officer and currently is an officer of Long Beach PD. He is one of the plaintiffs in this case. He has a statement that he would like to provide.